Today, we are going to talk about a fundamental, kind of hidden rule in contract law. It's something that decides whether close enough is actually good enough, or if it's a complete deal breaker. And it all depends on which of two legal worlds your agreement happens to live in.
All right, let's just jump right in with a scenario. Imagine you hire someone to paint your house sky blue, but the color they use is just a little bit off, a tad darker. Now, can you refuse to pay them? Okay, now picture this. You order 10,000 phone cases for your business, also sky blue, and they show up in that same slightly too dark shade. Does the answer change? You bet it does. In the eyes of the law, these two situations are worlds apart, and understanding why is the key. So why the different answers? Well, it's because there isn't just one single rule book for every contract out there. There's a huge divide, a fork in the road, really, that sends your deal down one of two completely different legal paths. And here is that fork in the road. On one side, you've got the common law. This is the old school, traditional set of rules that covers contracts for services like our house painter and real estate. Think of it as the rule book for actions. On the other side, you have the Uniform Commercial Code, or the UCC. This is a special set of laws designed just for the sale of goods. It's the rulebook for things.
So what exactly counts as goods? Well, the UCC keeps it pretty simple. Basically, if it's a thing and you can move it, it's a good. Cars, computers, grain, and yeah, our 10,000 phone cases. So what isn't a good? Well, the painter's labor isn't a movable thing. Neither is a house. And that simple distinction, is it a good or not, is what determines which legal world we're living in.
So let's head down that first path, the world of the common law. This is the painter's world, where the law gets that, when you're dealing with human services, demanding absolute, flawless perfection can be, well, a little unfair.
All right, back to our painter. He was hired to perform a service, right? Painting is an action, it's labor, it's not a movable good. So we are firmly in common law territory. And that means we're going to use a much more flexible yardstick to measure his work.
This brings us to a huge concept in common law: substantial performance. Under this idea, the law doesn't ask, was it absolutely perfect? Instead, it asks, did you get the main thing you bargained for? Was the mistake the wrong shade of blue, a tiny hiccup, or was it a major failure that ruined the entire point of the contract? Here, it's almost certainly not a major or material breach. So here's the bottom line. Under substantial performance, you can't just refuse to pay the painter. You can't. Why? Because you got the essential value. You have a painted house. He did the job. Even if it has a small flaw, you still have to pay him. But you're not left high and dry. You can deduct damages to make up for the mistake, maybe the cost to repaint or the difference in the value of the house. Okay, now let's switch gears. We're crossing over to that other world, the one run by the UCC. This is where our phone cases live. And let me tell you, the rules are drastically different. Forget good enough. Over here, the UCC demands perfection. Those 10,000 phone cases, they're movable things, so they are goods, which means the UCC is the boss. And the UCC has this little thing called the perfect tender rule, and it is every bit as strict as it sounds. And this is just, wow. This is where you see the huge difference. The smallest non-conformity. Think about that. It doesn't matter if just one case out of 10,000 is messed up, or if the color is off by just a hair. If the goods aren't a perfect match to the contract, the seller has breached the contract, and you, the buyer, are suddenly holding all the cards. And just look at your options. Unlike with the house painter, you are not stuck. You can say nope and reject the entire shipment. Or you could decide to keep them, maybe you can still use them, and then sue the seller for the difference in value. Or you can actually pick and choose. Keep the good ones, send back the bad ones. This gives a buyer a massive amount of leverage. Now, just when you're thinking the UCC sounds completely brutal and one-sided, the law throws in a plot twist. It's not a total free-for-all for buyers. The UCC has some built-in safety valves to give sellers a chance to make things right. And that's the question, isn't it? If the tiniest little mistake lets a buyer reject a huge order, couldn't that be really unfair? What if a buyer is just using a tiny flaw to get out of a deal they don't like anymore? Well, the law saw that coming. There are some important exceptions to this really tough rule. The two parties can always just agree to a different standard in their contract, and the rules are a bit softer for installment contracts. But the most important exception, the real plot twist, is something called the seller's right to cure. Think of this as the seller's do-over.
The buyer has to give the seller a shot to fix the problem if one of two things is true. First, if the delivery deadline hasn't passed yet, the seller can just send over a new perfect shipment. But, and this is key, even if the deadline has passed, if the seller had a good reason to think the off-color cases would be okay, maybe based on past deals, then the buyer has to give them a reasonable time to fix it. It's a fair shot to make it right.
So, we've walked through these two parallel universes of contract law. One is flexible, the other is super strict. Let's bring it all back together and really nail down why knowing the difference is so critical for pretty much anyone in business.
And this slide really puts it all side by side, nice and clear. For services under common law, the standard is substantial performance. A minor mistake means you still have to pay, but you can deduct for damages. But for the sale of goods under the UCC, the standard is perfect tender. That exact same minor mistake gives the buyer the power to reject everything. This is the whole ballgame. It all comes down to that one simple question: goods or services?
And that leads us to a fascinating question for the world we live in right now. What happens when you buy a smart car or a smart fridge? You're buying a physical good, but a huge part of its value comes from the ongoing software updates, which are a service. So which rulebook do we use? The flexible one for the service part? The strict one for the hardware part? As technology keeps blurring these lines, the law is going to have to catch up. We might even need a whole new rulebook for the smart economy. It's a question that lawyers and businesses are wrestling with as we speak.